Hello, and welcome everyone to this ASIL panel on climate change and global migration governance, locating international law in the defining crisis of our times. My name's Sanjula Weerasinghe, and I'm a Migration and Displacement Coordinator with the International Federation of the Red Cross and Red Crescent Societies, and an affiliate of the Institute for the Study of International Migration at Georgetown University and the Caldor Centre for International Refugee Law at the University of New South Wales. It's my real pleasure to moderate this session today with our four distinguished panelists who are here to help us learn how international law addresses human mobility associated with climate change, and also how it does not, its limits, and how these challenges could be addressed in the future. Before I talk about some of the evidence, I want to start by highlighting how we consider some of the key terms. First, it's important to recognize that under the human mobility umbrella, we're capturing a number of different forms of movement. We're capturing migration, which is regarded as predominantly voluntary movement and can also take place both within countries and across borders. We're capturing displacement, which is regarded as predominantly forced movement, and again, can also take place both within countries and across borders. And we're also capturing planned relocation, which is considered as the planned and more permanent movement of groups of persons from an origin site to a destination site. And it's often initiated by a community or the state. It's important to also recognize that some people don't necessarily move and are trapped or maybe immobile in the context of climate change. And this may be because of the vulnerabilities that they experience, or it may be because they are not willing to move out of harm's way. Turning then to climate change, we know that climate change is defined under international law, but the relationship between climate change and different forms of human mobility is complex and not linear. That relationship is mediated by a range of other dynamics. Climate change influences sudden onset hazards, such as floods and storms. Climate change also influences slow onset hazards, such as sea level rise and desertification. Both sudden onset hazards and slow onset hazards affect people's lives and living conditions, sometimes causing imminent harm and destruction, and in other contexts, leading to more gradual changes and environmental degradation, and also the deterioration of people's livelihoods and living conditions. What's important to understand here is that climate change is not the only cause of migration, displacement, or planned relocation, or human immobility for that matter. There are other drivers and structural factors, socioeconomic or political, for instance, that influence people's decisions to move. So getting to the evidence, we already know that climate change is impacting all regions of the world, with some locations experiencing regular droughts, others facing intense storms, and yet others facing the harmful effects of sea level rise and desertification and melting glaciers. I imagine that many of you have seen some of the dire warnings that have come out through the intergovernmental panels, reports and assessments recently, including in terms of what they spell for human movements. What we know is that cross-border migration and displacement associated with climate change is already taking place a lot around the world. We also know that every year, at least 20 million people are newly displaced within their countries by floods and storms and other hazards, sometimes for short periods and sometimes for protracted periods. Many people are also migrating internally, often invisibly, including as part of rural to urban movements. From the perspective of international law, what's important to appreciate here is that most human mobility associated with climate change occurs within countries. So even though much attention focuses on cross-border movements, most movement is actually taking place within countries. And when cross-border movement does occur, it's generally within the same region. So with this diversity in human mobility, in terms of the level of compulsion, in terms of the geography, in terms of the temporality, and the underlying structural and other factors, affects the role that international law plays. And the question then for us is, how should international law address human mobility associated with climate change? What are the issues that we need to and that we're trying to address? Is it, first of all, admission, rights and solutions in the context of cross-border movements, whether that's migration or displacement? Is it the prevention of arbitrary displacement and rights-respecting solutions when displacement does occur? Or is it opportunities for people to stay in their homes and in their countries if that's what people want to do? To answer these questions and to discuss the role played by international migration law, international refugee law, international human rights law, and other soft law frameworks, I'm really pleased to now introduce our four panelists. Walter Kalin, who will discuss cross-border migration and displacement and the role of international law. Kaylee Ober, who will discuss international and regional refugee law and the US domestic response. Cecilia Jimenez de Mari, who will present on internal displacement related to disasters, as well as slow onset movements within countries. And Jaya Ramji Nogales, who will talk about human mobility in the face of slow onset climate change. This session is going to run for about 1 hour, and it will include about 30 minutes of presentations by our panelists, with each panelist speaking for about 5 to 6 minutes. This will be followed by a moderated Q&A, and I really encourage you to please submit your questions through the Q&A app. For those of you who are hoping to get CLE credit from this session, if you're attending in person, please make sure that you find one of the AZOR volunteers who will be wearing a white ribbon on their badge, and register right now, and register also at the end of the session so you make sure you get your credit. If you're attending virtually, someone will contact you after the meeting to submit a self-certification form. So with that, let me introduce Walter Kalin properly. Walter is a Professor Emeritus for International and Constitutional Law at the University of Bern in Switzerland. He's the present envoy and chair of the Platform on Disaster Displacement and the former envoy of the chairmanship of the Nansen Initiative on Disaster-Induced Cross-Border Displacement. Over to you, Walter, to discuss cross-border displacement and migration and the role of international law.
Thank you very much, Sanchula. It's a pleasure to be here to address a rather complex task. We've been asked to locate human mobility in international law. And when we're talking about cross-border movements, both displacement, non-voluntary, and predominantly voluntary migration, then that's not so easy to locate these issues in international law, because there's no, as we all know, there is no climate refugee status, and there is no international convention on what IOM would call environmental migrants, or what the Platform on Disaster Displacement calls disaster-displaced persons. I have 4 points. First, one of the reasons for this difficulty is that the issue only made it rather recently onto the international agenda. True, in 2010, the COP16 in Cancun adopted the Cancun Adaptation Framework and mentioned that among the challenges to adapt to climate change are forced displacement, voluntary migration, and planned relocation. But after that, at the global level, nothing happened. There were, however, consultations ongoing at regional levels. The breakthrough came in 2015, and that's not that long ago, with, in March, the Sendai Framework on Disaster Risk Reduction. Unlike the previous document, the Hyogo Framework, the Sendai Framework addresses different forms of human mobility. Then in October, 109 states supported, endorsed the Nansen Initiative Protection Agenda, and in December, the Paris decision adopting the Paris Agreement on climate change set up or provided the foundation for the task force on displacement under the Warsaw International Mechanism on Climate Change. on loss and damage. 2018, December, COP24 endorses the recommendations made by the Task Force on Displacement and the Global Compact on Migration, which talks a lot about our issue, was adopted. Second point. So we have 3 policy streams. And the question is this progress, or is it further evidence of the fragmentation of international law? On the negative side, each of these work streams has different ways to conceptualize. For the climate change negotiations, it's climate change and displacement in that context. So whoever is displaced by an earthquake is not covered. The Sendai framework and the Nansen protection agenda are a bit broader. They conceptualize it from the perspective of a disaster, namely people flee when they are exposed to a natural hazard and too vulnerable to withstand its impact. But how to bring that together? On the positive side, lots of attempts to really have policy coherence. All these documents recognize that it's not global warming displacing people, that it's a multi-causal issue. The Paris decision talks about displacement related to the adverse effects of climate change. And then in the Global Compact on Migration, we have language imported from climate change law. There is this recommendation to provide temporary protection to people while adaptation in the country of origin is not possible. Adaptation, that's climate change law. That's not migration law. So there are chances to bring it together. Third point, all of these 3 4 documents I mentioned are legally non-binding. And implementation is still limited. We supported a baseline study for the forthcoming International Migration Review Forum, where we found that with regard to Objective 2 on addressing drivers, including environmental drivers of migration, since 2018, states have done quite a lot. This is not the case for enhancing pathways for legal regular migration for people affected by climate change and other disasters. And we don't have a clear norm at the global level solidly recognized on admission or on non-refoulement. Fourth point, but despite these weaknesses at the global level, there is law, but the law is at the domestic levels and at the regional levels. Domestically in the Americas, a study by David Cantor, for instance, in the Chicago Journal of International Law last year found that many countries have norms on temporary protection status, humanitarian visa. Guidance has been developed to harmonize the approaches in Central America, in South America, in the Pacific, New Zealand, Australia, some limited but still attempts to have immigration quota for people from the Pacific Islands in their domestic laws. And then very important, free movement agreements at the regional levels. That's probably the most tangible area of hard law. Free movement agreements serve economic purposes, but they have been used by people displaced or migrating in anticipation of disasters. In the ECOWAS region, Western Africa, in the Caribbean, Hurricane Maria 2017, for the Dominicans, the CARICOM agreement was used. Also the OECS, the Organization of Eastern Caribbean State Free Movement Agreement was used. And IGAD, that's the sub-regional organization in the Horn of Africa, recently adopted a new protocol on free movement, now with an explicit article on making free movement accessible for people moving in anticipation during or in the aftermath of sudden and slow onset disasters. And that's where we can build on. Thank you.
Thank you very much, Walter. And thank you very much for just highlighting all the background developments in this area, as well as highlighting the different spheres of law that are relevant, albeit some of them that are non-binding. I guess for many of us, sometimes the starting place is refugee law. And I'd like to now hand over to Kaylee Ober to tell us a little bit more about international and regional refugee law and how that fits into the architecture as well. Kaylee is a senior advocate and a program manager of the Climate Displacement Program at Refugees International, a member of the Task Force on Displacement, as well as a member of the steering group of the Climate, Migration and Displacement Platform. Over to you, Kaylee.
Thank you, Sanjula. First, I should warn everybody here, I'm not a lawyer, but I've been asked to speak on international and regional refugee law, and I'll do my best. And with that in mind, I'd like to start with one, I believe, contentious word, which Professor Kalin sort of alluded to earlier, which underpins how I view the law and how others view the law, right? And that word is climate refugee. So I'd like to interrogate this word from a variety of viewpoints, and since we are at a law conference, we can start from the legal perspective. And I think also Professor Kalin alluded to this, but the 1951 Convention does not in any way, shape, or form reference environmental change, disaster, or climate change within it, right? We know it's very narrow and specific. It's only defines refugees as those who cross borders, because of persecution on 5 sacred grounds, including race, religion, nationality, political opinion, and social group, right? So, and some might say purposefully narrow, right? So from a legal perspective, climate refugee is not a thing. Now, from an academic or research perspective, there's additional challenges, and that's problems with calculation and attribution. To what extent can we truly point to climate change as the only or majority driving factor behind someone's movement? It's very difficult to do so, and that's what Sanjula was mentioning earlier. It's very multifaceted and complex. So that's an additional layer we'd have to grapple with if we were to start considering, okay, should we determine if climate change should be considered within the Refugee Convention? I think additionally, refugee advocates are sort of, they have a couple of fears. One is that we will remove sort of the attributes that are much more attached to human dimensions like governance and point to things that are sort of amorphous and harder to pin down than those who are actually responsible. So Syria is a case study in point, right? So Syria is often held up as the first sort of case of climate refugees. Now, I will admit that prolonged droughts, inability to grapple with those droughts are definitely linked to climate-related factors. However, it really sort of elides the fact that the Syrian government was responsible for many of the reasons why people were not able to adapt to that drought, right? Number one, it had longstanding agricultural policies that overused underground or groundwater aquifers, right? So decreasing access to water, water scarcity, had inefficient irrigation methods in place. It also liberalized the economy in the 2000s, as many economies were doing then, and it got rid of subsidies for farmers that really relied on those subsidies to continue their livelihood, right? So refugee advocates are also very wary about sort of renegotiating, reopening up sort of the black box of the Refugee Convention for that reason, and also because, it's a fairly strong international law. It is binding, and they're afraid that if we were to renegotiate it, it would actually end up watering it down. So taking into account sort of the political economy of sort of international frameworks today, right? Despite these challenges, there has been some progress in recent years to really grapple with the Convention's applicability in the context of climate change. In particular, in October 2020, the UN Refugee Agency, UNHCR, published the legal considerations regarding claims for international protection made in the context of the adverse effects of climate change and disasters. So a mouthful, but this is purposely done, right? Because they're trying to be careful about how this is framed. And I've just pulled out a couple of text points that I think would be interesting for all the lawyers here today. So paragraph 5 specifically makes the case that assessment of claims for international protection should, made in the context of the adverse effects of climate change and disasters, should not focus narrowly on the climate change event or disaster as solely or primarily natural hazards. Such a narrow focus might fail to recognize the social and political characteristics of the effects of climate change or the impacts of disasters or their interaction with other drivers of displacement. So essentially, just focusing on climate change doesn't necessarily mean that you are assessing claims for international protection fully. They go into more detail here, and in paragraph 10 they say, in the context of the adverse effects of climate change and disasters, a well-founded fear of being persecuted may arise especially for people who are already marginalized or vulnerable. The willingness or ability of a state to prevent the adverse effects of climate change and disasters, as well as to respond adequately to them if they occur, may vary for particular groups, reflecting differences in race, ethnicity, religion, politics, gender, or social groups. It could, for example, include situations in which a government withholds or deprioritizes protection by denying relief aid to specific populations, where post-disaster relief is politicized, or where the environment, its natural resources, or ancestral lands are deliberately destroyed to persecute particular populations. So it's important to keep in mind. Paragraph 11 also claims people may also have a valid claim for refugee status where the adverse effects of climate change or disasters interact with conflict and violence. These adverse effects may exacerbate violence or vice versa and render the state incapable of protecting the victims of such violence, resulting in a well-founded fear of being persecuted for reasons of one or more convention grounds. So these are things to keep in mind, trying to find room for maneuver within the convention. And I think it's actually, although it sounds a little bit complicated, right? It's UNHCR's way of really showing or demonstrating that they're trying to really work through this issue. And this is quite novel. In the recent past, they have not been willing to really talk about or engage on this issue because of their mandate. So this is quite, to me, progressive. Within this paper, there's also a note about regional refugee definitions, which are important because regional refugee definitions, like the 1969 OAU Convention and 1984 Cartagena Declaration, provide a more generous approach to defining refugee protection to, inter alia, every person who, owing to events seriously disturbing public order. So there's a lot of refugee scholars, Sangela included, who have made reference to these regional sort of frameworks and this ability to perhaps contextualize or add this climate change dimension under this more expansive sort of definition of seriously disturbing public order. So small gains that may come to fruition in a variety of ways, through the courts potentially, but also through administrative application. And so hopefully we'll see some movement on that, and I'm sure the other speakers have things to say on that, and I'll wait for a Q&A to really dig deeper. Thank you.
Thanks so much, Kaylee. That was wonderful. And I'm already seeing some questions coming in response to your summary of UNHCR's legal considerations as well. And I'll pose them in due course. I'd like to now hand over to Cecilia Jimenez de Mari, who is the Special Rapporteur on the Human Rights of Internally Displaced Persons. As I said at the beginning, most movements associated with disasters and climate change take place within countries. So Cecilia, over to you to just enlighten us on what that looks like and what should be done in relation to it.
Thank you very much, Sanjula, and I'd like to give thanks to ASL for this invitation to present in this panel. As the title of this panel provides, climate change is really the defining crisis of our times, and this is manifested by the intense effects of climate change on mobility within the countries themselves. And Julia already alluded to the fact that there have been more new displacements because of disasters, most of which would be linked to climate change, vis-a-vis conflict and violence. So just the 2020 figures provide that there were 9.8 million new displacements due to conflict and violence in 2020, due to war and other types of violence. But as far as disasters are concerned, the figure was actually 30.7. In this short presentation, I would like to really articulate international human rights law in the discussion of human mobility in the context of climate change, with the United States as an example, because majority of the oceans here come from the USA. While we all realize the dramatic effects of sudden onset hazards on populations, such as those of Hurricane Ida in Louisiana in August 2021, not many of us are fully aware of the tremendous effects of slow onset hazards. Maybe we do know about it when it comes to the effects on polar bears and penguins. However, we have to be fully aware as well of the tremendous effects of slow onset hazards on people, and particularly, as an example, the coastal regions of Alaska. Disaster risk reduction and mitigation also is usually focused on sudden onset hazards and are now only starting to include slow onset adverse effects of climate change. I therefore would like to focus on the latter, as it is not much discussed in human rights terms as related to internally displaced persons. Indeed, human mobility in the context of slow onset adverse effects of climate change can take many forms, including displacement, migration, planned relocation, among others. And this may be internal or cross-border. In most cases, however, movement is, and I would like to insist on this, movement is not entirely voluntary or forced, but rather falls somewhere on a continuum between the two, with different degrees of voluntariness and constraint. At the same time, where such voluntariness is absent, such mobility would fall squarely in under the notion of forced displacement. Where internal displacement is concerned, I actually presented to the General Assembly in 2020 a report focusing on internal displacement in the context of slow onset adverse effects of climate change, where I really emphasized the necessity of, one, adopting a human rights-based approach, and second, mainstreaming this approach in discussions and responses. In fact, there is now extensive evidence of the widespread impacts of climate change on the enjoyment of human rights, such as the rights to life, health, housing, food, water, and education, cultural rights, and collective rights, including the rights of indigenous peoples and their right to self-determination. In short, those impacts contribute to displacement, and displacement further impacts the enjoyment of human rights. Under the 1998 Guiding Principles on Internal Displacement, those human rights guarantees are restated comprehensively from the context of prevention, protection, and durable solution, and I also would like to insist that these apply to the context of climate change. In fact, just prior to that report to the General Assembly, in September 2020, as a Special Rapporteur on the Human Rights of IDPs, I actually issued communications to the United States government. I was joined by 8 other Special Rapporteurs, particularly the Special Rapporteurs working on cultural rights, obligations relating to environment, right to food, right to adequate housing, indigenous peoples, extreme poverty, contemporary forms of racism, and the human rights to a safe drinking water and sanitation. The communications in the US was on information we received concerning the alleged failure of the United States of America to protect indigenous tribes who live along the coastal regions, especially of Alaska, from the impacts of natural hazards, particularly onset, and the adverse effects, particularly slow onset and the adverse effects of climate change. And these affects the numerous human rights that I just enumerated. Let me read to you the main information we articulated to the US government. Quote, coastal indigenous tribes in the states of Louisiana and Alaska have been severely affected by the slow onset adverse effects of climate change, such as sea level rise and saltwater intrusion and resulting coastal land erosion, and extreme weather events such as hurricanes, storms, and flooding. The environmental impact of the Mississippi River levee system and the destruction of wetlands caused by oil and gas exploration and drilling have also contributed to land erosion and subsidence in the region. Such events have endangered the subsistence and cultural traditions of these indigenous peoples, affecting their health, life, and livelihoods, and have led to the loss of sacred ancestral homelands and the destruction of sacred burial sites. As a result, these lands are becoming uninhabitable, and many indigenous families have been forcibly displaced from their ancestral lands. The government of the USA has allegedly failed to support the affected indigenous tribes to identify and implement community-led adaptation strategies by failing to allocate resources, provide technical assistance, engage and consult with the affected indigenous tribes, thus placing them at existential risk. The government has also allegedly failed to protect the tribe's historic and cultural sites through the existing historic preservation mechanisms, such as listing them on the National Register of Historic Places, despite the clear threats on indigenous historical and sacred sites. The communications we issued further requested the USA for further information and meanwhile to implement interim measures to prevent the alleged violations of human rights that we had raised. Unfortunately, at that time, we did not receive a response from the then US government. In July 2021, therefore, I sent a letter to the US government requesting to visit the USA to allow my mandate to examine in situ issues related to disaster displacement in the country. The State Department has appropriately informed me that they cannot accommodate my request this year because of a backlog of visit requests from special rapporteurs. Well, you know why. Given the continuing dire situation of the effects of climate change in the USA, however, especially insofar as indigenous peoples are concerned within the context of the slow onset adverse effects of climate change, this visit has to happen sooner than later. I also would like to note at this point in time about the Biden report released last year concerning climate change and migration, which I would like to insist is also applicable within the United States. As slow onset adverse effects of climate change can turn definitely into disaster displacement, which therefore pose direct risks to human rights, it is important to identify three essential areas for consideration. The first is the vulnerability of persons impacted in terms of human rights. And the second is enhancement of their political agency. And particularly where communities living in certain areas, such as low-lying coastal areas, small island states, and Arctic ecosystems, are more exposed to slow onset events and therefore at higher risk of disaster displacement. These have to be looked at very seriously. The second, of course, is a human rights-based approach necessarily has to integrate the notion that even though specific groups may be particular or are particularly vulnerable to adverse effects of climate change and related internal displacement, they also have great agency. And in many contexts, they display remarkable strength, resourcefulness, and resilience in the face of disasters and displacement. The third point and last point I would like to make and conclude this presentation is the importance of state responsibility, who remains primarily in charge of the human rights obligations vis-a-vis its populations, including the most vulnerable populations, part of whom would be internally displaced persons. Side by side to this, however, again, I would like to insist, is the essentiality of solidarity from other members of the international community, including other states. And this should not be articulated merely in the form of humanitarian assistance, complementary to the state itself, but likewise in their own implementation of its protective and due diligence standards or norms under international conventions such as the Paris Agreement. So let me stop there for a while in order to allow more discussion later on. Thank you very much for giving me the floor.
Thank you so much, Cecilia, and thank you so much for bringing greater attention to the slow onset impacts of climate change as well, and the plight of Indigenous communities, as well as kind of the recognition that these movements are not at all within a forced and voluntary binary, but in many cases are not at all voluntary, but that recognition needs to be taken into account. I think these are, and then the agency aspect as well. And I think these are issues that will very much resonate again in the presentation by Jaya Ramji Nogales, who is the Associate Dean for Research and the I. Herman Stern Research Professor at Temple University Beasley School of Law. She's also a counsellor of the American Society of International Law and was a founding co-chair of the Migration Law Interest Group. So over to you, Jaya, to talk about slow onset climate change and human mobility.
So thank you so much, Sanjula, for keeping us organized. A huge thanks to the Society for making it possible for Sanjula to be here, to Rachel Lopez on the annual meeting committee, and to my co-panelists who actually set me up nicely, so I might have a possibility of staying within my 5-minute time frame, because we are thinking very similarly on these issues. What I want to focus on is the gaps in binding international law when it comes to human mobility. And then I also, as Cecilia did, want to emphasize slow onset climate change. Sudden onset climate change is, of course, important, but tends to pull away more of the attention, and tie this into the limitations of international law in governing human migration more generally. So around climate change and human mobility in particular, there's not much binding law, as my co-panelists have said. And as they've also said, that law is narrow in scope, is very focused on specific causes to the detriment of other causes, and has a crisis orientation. And this is a particular problem when it comes to slow onset events that build up progressively over time rather than culminating in a single dramatic act. International law really struggles to remedy, in particular, those situations. And I'll talk a little bit about what international law and institutions should do. So slow onset climate change, I like to link with the concept of slow violence, which is a term coined by Rob Nixon to describe harms that are caused by structural inequality. And the key point I want to make is that slow violence is often rendered invisible. And I think it's important for all of us to think about the role that international law plays in making invisible the harms that cause migrants to flee slow onset climate change, right? Because international law determines which harms will be validated and which harms will be overlooked. And of course, the harms that are overlooked are often the harms suffered by the most vulnerable. So cross-border migration in the face of slow onset climate change, as my co-panelists have said, it doesn't fit neatly into international law's categories. First of all, the reasons for movement are diffuse. There are several causes. The causal chain is very complex, right? So drought and increased temperatures may be one reason, but as we see in the case of migrants, for example, from Guatemala, they're facing inadequate government planning and support. They're facing the volatility of global commodity markets. And so really the key reason for movement, if I had to point to one reason, is vulnerability. And there are so many factors that contribute to vulnerability and diminish resilience that result in movement. As my co-panelists have also said, on a spectrum between voluntary and forced, it's very difficult to categorize the reasons humans move in the face of slow onset climate change. And here we also have a crisis, but it's not immediate, but rather eventual. We don't see dramatic, large-scale flight from a sudden event. We see temporary, seasonal, individual decisions. Maybe one member of a family travels overseas so they can support the rest of the family that's suffering the consequences of slow onset climate change. And then, as Cecilia said, right, first we see national movement, and then again in the case of Guatemala, you see rural smallholding farmers move to urban situations that are very, very dangerous, and that's what pushes them to make the move regionally, and then there's no support regionally and they move internationally. And finally, I just really want to emphasize the human mobility frame. In my work with migrants, as I'm sure is true of everyone on this panel, most people would rather stay in their home than leave if their home could be sustainable. Now, there are certainly people who want to move onwards, but we need to think about making that a possibility. And also, only the strongest can leave, which means that the most vulnerable are the ones who get left behind. So we really need to think about those who are left behind. As my co-panelists have explained, international law has really no binding framework to protect migrants who cross international borders in the face of climate change. As Kaylee explained, refugee law asks for this precise causal delineation. On one of the protected grounds, you have to point to a specific perpetrator. That does not work very well in the case, particularly of slow onset climate change. It wants to see imminent harm, a well-founded fear of future persecution, and this movement needs to be forced, right? Which as Cecilia has explained, it's a difficult spectrum. Walter talked beautifully about international environmental law. He's the expert here, so I'll just repeat what he says. Is right. This has been on the agenda for over a decade, since Cancun, which is good news. But again, we often see a focus on disaster. Right, so slow onset is certainly mentioned in the instruments, but it's less central, and we see this sharp distinction between forced and voluntary migrations, and also an emphasis on the human rights obligations of the home states rather than an emphasis on the obligation of the migrant receiving states where these people need to flee to be safe. So let me talk a little bit about what international law should do. So my argument is that it should take direction from those most at risk of serious harm from slow onset climate change, including vulnerable subsistence farmers, right? So international law and institutions could enhance communication between smallholding farmers and those who can assist them, right? Poverty reduction is an integral part of this work. Regional free movement, right? As we may get questions about in Q&A, and my co-panelists have already spoken about that. That's an option that might work, but those regional free movement areas need to be expanded between those beyond those that exist already. I recommend Maxine Burkett's work on climate reparations and Carmen Gonzalez's work on climate justice. Those are very thoughtful works that might lead us to some kind of financial support for development, as I've said, for adaptation, for mitigation strategies. This all has to be part of the solution, enabling reparations from the global north, maybe from states, maybe from corporations. International law and institutions need to take the lead from vulnerable groups. There's local and indigenous knowledge that can be tapped to guide and provide support for what might work in a specific area. And then I want to underline just the human mobility approach that I started with, to enable choice, to enable migrants to stay if they prefer to stay with technical support that they need, or to move safely if they prefer. And of course, in the absence of binding treaty law, to make use of all of this soft law that my co-panelists have talked about and really put it to work, naming and shaming and doing what we can with the instruments that we have. So I'll stop there because I'm looking forward to the conversation among the panelists. Thank you.
Thanks so much, Jaya, and thanks so much also for just highlighting how we could all move forward. A lot of the themes that you just raised again resonate very much with what Cecilia was talking about in terms of agency and empowerment, and who we should be taking direction from in terms of how we move forward. We've had a lot of questions come in, and we have about 15 minutes of Q&A now. And I guess I have to start with this one because, as I said before, refugee law ends up being kind of the first framework that everyone thinks about in terms of addressing this issue. And Kaylee's already highlighted the UNHCR's legal considerations that UNHCR's put out in terms of highlighting the ways in which refugee law might be relevant. But one of the questions that's come in is whether it would be helpful to have a protocol to the Refugee Convention relating to climate refugees, so as to avoid opening up the Refugee Convention, which is what you had talked about. And otherwise, whether we should be leaving the development of refugee law to progressive change. So perhaps, Kaylee, to you, and maybe to you, Walter, as well, I wonder whether you'd like to respond to that question. Feel free to go, whoever wants to go first, feel free to go first, and then I can hand over to others.
Just the easy question first. Thank you. I think in an ideal world, we would have something like an additional protocol, but as I alluded to earlier, I don't really believe we live in a world in which that would be possible, unfortunately, because of politics. I know, Cecilia just let out this big sigh. Yeah, that's kind of a pessimistic point of view, but I am an advocate, so I'm also a realist. And I think that if we could achieve that, we should achieve that. I think the challenge for me is I believe there's an overemphasis, as my other panelists have said, on refugee law in particular, despite the fact that movement is so much more diverse than that. And a lot of the movement is not across borders. And a lot of the people who need the most help are not the ones necessarily moving across borders. So I think that, yes, in an ideal world, we would have more binding international law. We might have an additional protocol. In the world we have, we need to put our eggs in many baskets. Thanks.
I'm a bit more skeptical for two reasons. First, if we stay within the framework of refugee law, then we conceptualize the issue in terms of causes. And if I were a climate refugee asylum seeker, and I would have to make credible that this storm which destroyed my crops would have not been destroyed if emissions would not be what they are today. Even for scientists, this is difficult. For a refugee, climate asylum seeker, not possible. So I think the perspective should rather be what the human rights approach is, namely the question of returnability. What are the consequences if the person would have to go back? And then we can, for instance, refer to the approach used by the UN Human Rights Committee in the Etiota case. If situations deteriorate to a level that the right to life comes into question, that it's a life-threatening situation, regardless of what the cause is, then protection has to be granted. So for me, it rather should be a human rights instrument than a refugee law instrument. The second thing, if you go, for instance, to the Pacific Islands, and you are talking to people, as I have done in Kiribati, etc., the answer is, we don't want to become refugees. We see refugees on TV in their camps. We don't want to end up like this. We want to have choice. We want to have the possibility to decide where and when to go. And that's a migration approach. And that's why before I said free movement agreements, which need to be further developed, are better responding to issues of agency, of planning. Who here would like to end up in a humanitarian situation? If you can avoid it, even if you have to go. And these are the reasons why I'm very skeptical of that kind of an approach.
Angela, can I add on to my answer? Just really quickly, I think from an advocacy perspective, and I've said this to many people before, sometimes the argumentation around sort of refugee as a label, as the end-all be-all label, is counterproductive. So it just feeds into this unnecessary binary of deserving versus undeserving people that are moving, right? Refugees are deserving, migrants are not. So can we take a more human rights approach? I think that would be helpful. I think the one thing is human rights law, as we know it, is not necessarily being adhered to or respected to the same degree sometimes as something like the Refugee Convention, although that is certainly under attack as well. And also with things like immigration law, like freedom of movement, it's absolutely at the discretion of immigration officials at the border. So in some cases there are, and there have been in the past, biases about this. So again, just thinking about this with eyes wide open, this is a wicked issue, and we don't have pat answers. But I just wanted to add on to that because we need to reflect about all the layers of sort of the inadequacies of different sorts of law and policy. Thanks.
Yeah, thanks so much, Kaylee, and thanks so much, Walter. And I think in terms of talking about the inadequacies of the existing frameworks, one of the frameworks we haven't really talked about is international human rights law and how it relates to cross-border movements as well. And another question that's come up is in relation to the Toyota decision that you just touched upon, Walter, to some extent. And the question is really, is it an incremental step forward, or does it really add little to the already meager human rights jurisprudence on this issue? So it'd be great. The questions are really easy, I can say, but I wonder whether you can answer that before we kind of move on to looking at what other options are available and how soft law might then be transferred into kind of more hard law frameworks.
Okay, I can't answer that on behalf of the Human Rights Committee, but I take the perspective of a former member of the Human Rights Committee. On the one hand, I think it is really building up on the case law of the Human Rights Committee and also the regional human rights courts, saying that a state sending someone back to serious harm to life, but also intense suffering, is committing a human rights violation. So that's this returnability perspective. And they just applied it now to a new set of facts. In that sense, it's not the big step. Also, the outcome, of course, was negative for Mr. Toyota, because I said situation in Kiribati is not yet at the stage where your life would be threatened. But on the positive side, it helps to, in a way, reorient the discussion and helps to move it away from, you've just heard it from me, the too narrow focus on refugee law. Having said that, refugee law plays a role. There are situations where these people qualify even under present law, as Kaylee has explained. But we have to move beyond that. What I think will be important is how now domestic courts will take up the message from the Toyota decisions in cases of rejected asylum seekers, for instance, and to what extent where they can do it. This depends a bit on the country and the law of the different countries, to what extent they can apply human rights law. If they do that, there is a potential there.
Can I just add very briefly to that? I am on board with that analysis of the Toyota case, but also just wanted to note that the African Commission on Human Rights and the Inter-American Commission on Human Rights have rights. So these are the regionally progressive locations for human rights law development, and they have linked the right to life with the loss of land, particularly for indigenous people, because it takes on a whole nother dimension, as Cecilia was saying, with indigenous people. So we see some of these regional solutions maybe expanding and pushing the needle forward as well.
Thanks so much, Jair and Walter and Kaylee. I think just been told we have about 6 minutes left, and I have a range of questions that I'm not going to get through. So hopefully the organisers can work out a way to share those questions with the panelists at some stage so that you might be able to provide responses. But I have one last question really in terms of trying to wrap this session up, and it's a question to all of you. I guess from your specific vantage point and the issue that you've discussed, whether it's cross-border mobility or internal mobility, I guess it'd be great to hear from each of you on what you think are the key strengths of the present architecture that we have to address human mobility associated with climate change, and how you think the law needs to develop, whether it's kind of moving from soft law frameworks to binding hard law, whether it's really focusing in on the regional level, whether it's looking at the agency of different people, whether it's about holding states to account in terms of their responsibilities. So Cecilia, perhaps I can start with you on that easy question.
Okay, everything you said, Sanjula. Well, thank you very much for the question. I think the great thing is that we do have frameworks, even though they are soft law frameworks, as far as the human rights of internally displaced persons are concerned. Of course, I refer particularly to the guiding principles on internal displacement, but mind you, even though it's a soft law framework, the principles in the guiding principles are actually I mean, some of them are actually hard law and can be and have been derived, depending on the country, from treaty law obligations. So it is really important to look at the application of such soft law or principles, if you want, to the human rights of IDPs. Particularly, international law can only be relevant to people like IDPs and other affected populations on the ground through the direct implementation of the obligations of the state. And we have that. But I think that where things should move on is actually to ensure that there is a dynamic engagement of the law from the different sources of law, I mean, different types of law, like environmental law, international disaster law, even due diligence law in terms of protection and solutions. And we're not really going further in this, and this is where I think we should push in order that we can actually get what Jaya alluded to, climate justice for these people, particularly, of course, in my point of view, internally displaced persons. Thank you.
Thanks, Cecilia. And Jaya, over to you.
Thank you. Yeah. So I think in the current political climate, I think I have the most hope for regional solutions, both in terms of climate change and in terms of migration more generally. I think, as Walter says, it enables just simply more autonomy and movement. And if we look at what's happened in the Mercosur region in response to Venezuelans, I think that's just incredibly, it's not perfect, but I think it's incredibly promising. So that's, where I think I would like to see the most energy devoted, and I think in particular because in every situation, I was just reading an article about Ukrainians saying they want to stay close to home because they want to go back if things get better, right? And so I think it's promising from a number of perspectives. I will lay out a couple of warnings, though. So regional solutions can be used as containment mechanisms, and that's not what we want to see. They should not be used as holding spaces to prevent further onward mobility, so that it has to include resources coming in to enable adaptation, mitigation, and to enable people to remain safely, not as we saw with the Syrian situation where there was not enough resources and the UNHCR was calling the alarm, and so what happens? Onward movement, right? And that's not, I don't think, what anyone wanted to see in that situation. And we also have to worry about exceptionalism because, of course, in the Americas, right, we see very progressive development in the inter-American system, but the U.S. is just doing what it wants. Biden's climate change migration report aside, I think people should read that. It's a really worthwhile document. But I would like to see something like that happening in binding law. So I think that those are the two things that we really have to keep our eye on. But I do think, the regional is the way forward and holds a lot of promise in terms of thinking about human mobility as autonomy, as people making choices about what they want to do, which should be the end goal of any migration regime.
Yeah, I totally agree with that. Yeah, but just to add, and I've said this before, which is I still think there's a huge implementation gap. So yes, there's a lot more progressive sort of frameworks at the regional level. They should be applauded, but I think that there's a missing step to really enabling those frameworks to work on the ground and for people that need them the most. Some very salient examples for me is like the freedom of movement in CARICOM. It's been unevenly applied based on where you're from. So, for instance, post Hurricane Maria, a lot of the Caribbean countries, even though Haiti's part of CARICOM, were not allowing Haitians to come to their countries. So we can see sort of the biases in the sort of inequity functioning even at these levels. So I think it's just as equally important not to have new laws or, put in a lot of stock to just things on paper, right? We have to understand how they're actually working on the ground. Thanks.
I don't want to repeat what yours already said. I fully agree with them. But you ask about the strengths of the present situation. I think there are two elements. If you're looking at when people have to move, it's when they are exposed to a hazard and too vulnerable to withstand it. And we have a whole toolbox provided by these instruments to reduce the hazard. That's climate change, that's mitigation, the Paris Agreement, of course, implementation, but at least we have the framework there, helping to move out of harm's way, reducing exposure. That's planned relocation internally, that's migration pathways, and then to reduce the vulnerability, that's disaster risk reduction, climate change adaptation. In many other areas, we don't have that kind of holistic approach, but it's important to look at it not in a siloed way, but as a holistic approach. And the second strength is that for all these instruments, climate change, disaster risk reduction, migration, we have formal follow-up processes. The Global Forum on Disaster Risk Reduction in Bali in May, the International Migration Review Forum, all the COPs for the climate change issue. And again, we don't have that everywhere in international law, that every 4 years states have to come together and to show whether they are making progress or not. It's difficult, it's something where we have to work on, and that's our role as international lawyers, isn't it?
So with that wonderful summary from all of you, thank you very much, Walter. Thank you very much, Kaylee. Thank you very much, Jaya. And thank you very much, Cecilia. We're right on time. So I'm wishing you all a wonderful rest of the conference. And thank you to all the participants who engaged in this. I hope that the ASIL organizers can also help you get in touch with the panelists if necessary to answer some of the other questions that we were not able to answer. So thank you for that, and bye.